May it please the court, counsel, ladies and gentlemen, we are finally at this place where we get a chance to talk about this evidence, to talk about how and why the state has proven these charges beyond a reasonable doubt. And in doing that, I hearken back first to the very first thing that Ms. McMullen said in her opening statement. And that is the words uttered by the defendant, Timothy Burke, sometime before these murders. The only way to get rid of a narcissist is to kill them. What a foreshadowing that was. What a foreshadowing of things to come, because the evidence has in fact proven beyond a reasonable doubt that Mr. Burke became convinced that Davido was a narcissist and was the source of his problems, the source of his difficulties. And the only way to get rid of a narcissist is to kill them. What I'm going to do in this closing argument is go back through the evidence, organize it, and to try to give you, if you will, the narrative of this case. When we're talking about testimony, unfortunately, it comes in pieces based on the witness, right? So the opportunity I have now is to put that all together and to give you a timeline and a narrative for this case while highlighting all of the pieces of evidence that have been introduced to prove this case beyond a reasonable doubt. But I also need to do that in light of the instructions, because your role as a juror, when you go in to deliberate, is to now look at that evidence that's been presented, and now look at that in light of the instructions of law that the judge has given you, and make decisions about what has been proven in this case beyond a reasonable doubt, and perhaps what has not been proven. Okay? So I'm going to actually start this argument more by talking about and discussing the instructions of the court. Here we have Davido and Karen in life. Two people who, by all accounts, generous people, good neighbors, right? Helping out. Davido caring for a piece of property where he let people stay and rent from him who may not have been able to do that anywhere else. Karen, a chiropractor, a healer, if you will, a healthcare professional, who was, as you heard, incredibly dedicated to her practice and to her patients. And in one evening, both of those people taken. Everything that they were, their lives, their hope, gone. Because Mr. Burke decided that the only way to deal with a narcissist is to kill them. So let's start with the instructions of the jury. Let's go to the jury. Let's start with what these instructions, the guidance these instructions give you, okay? And the way I'm going to lay this out to you is kind of like, what is your role as a juror? Because a lot of these instructions are giving you guidance as to how to go about digging into this case, how to go about deliberating on it, and how to go about making decisions that are within your purview, okay? And let's start then with what jurors do, okay? What are the things that you do once you get in the jury room? Well, one, you discuss the case with one another in an effort to reach a unanimous verdict. Discussion. It is the very essence of deliberation, right? And you heard one of the instructions of Judge Skinder was to make sure that everybody has an opportunity to be heard, to discuss this case, to give their thoughts about the evidence. And just as importantly, the effort is to reach a unanimous verdict. In Washington, verdicts of a jury in a criminal case must be unanimous, one way or the other. Unanimous as to guilt, unanimous as to what we have been calling NGRI, and or unanimous as to not guilty. Okay? The idea is to get to a point of unanimity. You decide the facts of the case based upon the evidence presented in court. Judge Skinder has been reminding you of this throughout the entire trial, that the evidence that you have, that you make your decisions on in this case, is only the evidence that came to you in this courtroom, right? Through the testimony of the witnesses and the exhibits that were admitted. Nothing else. You are to follow the instructions of the court regardless of what you believe the law is or should be. Okay? So that means you are obligated, duty-bound, if you will, as jurors, to follow the instructions of the court. Even though maybe you thought the law was different, or maybe you think the law should be different. Okay? Which is an opinion that you have an absolute right to hold. But in your role as a juror, you are duty-bound to follow the law of the court as that's been given to you. You determine the credibility of the witnesses, and that is solely your province, right? And we talked a little bit about this in jury selection, that one of your roles is to evaluate credibility. And I broke that out into a couple of different pieces. One is accuracy and one is honesty, okay? And both of those are before you. Because clearly witnesses can be honest but inaccurate, or they can be the other way around, or a combination of both. But it's your decision. It's solely your decision. You're to act impartially with an earnest desire to reach a proper verdict. Impartiality. That is why one of the questions that you were asked over and over and over again in jury selection is, can you be a fair and impartial juror, right? Because impartiality is a core requirement of what you're about to do in discussing this case. You apply the facts to the law, and in this way decide the case. So you go through the evidence, you decide what's been proven, what hasn't been proven, you look at those facts, and then look at the law and make ultimate decisions about what your verdicts should be as they were laid out in the jury questionnaires, the verdict forms. Okay. Similarly, there are things that jurors should not do. Okay, and those were also contained in the instructions. And I'm obviously kind of doing an overall look at the instructions, not necessarily focusing in on one specific instruction. One is, do not consider or discuss the evidence which was not admitted or which the court asked you to disregard. Okay, so anything where the judge said he was sustaining an objection, something's not admitted, or asked you to disregard something, I don't actually recall that happening in this trial. But if you do, and it did, then you are bound to disregard it, not consider it. Do not consider the remarks, statements, or arguments of the attorneys as evidence. Disregard any remark, statement, or argument not supported by the evidence or the instructions. So, everything that I say up here today is not evidence, and it's not intended to be evidence. The same with the slide deck that I'm using here. The slide deck is not evidence. That is to assist me in presenting my argument to you. And quite frankly, it's a tool not only to help you follow the argument, but to keep me organized in my presentation. But it is not evidence. It will not go back to the jury room with you. Okay? The PowerPoint is simply a tool that I use to assist me. Okay? And that's the same for defense counsel. When defense makes their closing argument, what defense says is not evidence. And if either one of us say anything that is inconsistent with your memory of the evidence, then disregard it and go with your memory of the evidence, because your memory of the evidence is what matters. Okay? Do not make any assumptions or draw conclusions based on objections. We didn't have a lot of objections in this case, but there were some. As the instructions said, questions get asked sometimes where the lawyers have a right to object, and sometimes, as they said, a duty to object. We're actually not doing our job if we don't object, right? Bottom line is, that's not a consideration for you as to whether an objection was made to a certain question or piece of evidence or anything like that. Okay? That is solely the right of the lawyers and the duty of the lawyers to bring legal issues before the court. You're not to consider punishment. You're not to consider punishment. Juries don't have anything to do with punishment in Washington. So that is not part of your consideration, except insofar as to make you careful. I mean, obviously, this is an important case. There are important consequences that are in play here, to your verdicts, right? But that only matters in the sense that it makes you careful. It makes you intentional as to your deliberations and your decisions, right? But it's not up to you to determine whatever punishment there might be following your verdict. Do not let emotions overcome your rational thought process, right? So this is the idea that your decision needs to be intellectual, if you will. It needs to be a thoughtful decision, not an emotion decision. Deliberating is a way of thinking, not a way of feeling, okay? So make sure that you are, staying in that place of rationality and thought. You might have also picked up on an instruction that kind of lays out to you two basic categories of evidence. And I'm not going to spend a long time on this, but I just want to mention it, because sometimes we have this everyday use of the word circumstantial evidence, like, that's weak evidence. It's sometimes kind of used in that context, right? The case is only circumstantial. Yet the law, when you look at that definition of circumstantial evidence, gives you a little bit different way of thinking about it. So I want to just spend a minute on that. So there's two types. Direct evidence, right? So direct evidence is that which is directly perceived with the senses. That's the evidence that people see, hear, smell, touch, whatever, right? One of the senses is involved, and they are, from the witness stand, relating to you something that they saw or heard, right? Or, otherwise perceived. That's direct evidence. Now, direct evidence, that can have its issues as well, right? Because, again, you can run into issues of accuracy or honesty in terms of how things are being related. Perceptions are being related. Then we have a category called circumstantial evidence. And that's evidence from which, based on common sense and experience, you may reasonably infer something that is at issue in the case. Okay. As an example, DNA. We generally think of DNA as, pretty important, or what can be very important evidence. And sometimes if I would ask that question, is DNA direct or circumstantial? People might say, well, it's direct evidence. And the reality is, it's a form of circumstantial evidence. Because what we're saying is, by doing the scientific testing on whatever the sample is, if the DNA comes out, a profile comes out of a person, then we can infer, even though nobody may have seen it, we can infer that somebody touched something, or was present somewhere, or bled, or, the list goes on. Even though nobody actually saw that or perceived it, we're drawing an inference because of that, the presence of that DNA. That's a form of circumstantial evidence. Now, do you need to really worry a lot about that? And the answer, according to the instructions, is not really. You don't really have to go through the evidence and say, well, is that direct evidence or is that circumstantial evidence? Because at the end of the day, the instruction basically says, evidence is evidence, right? And it is solely up to you to determine the strength or the weight of that evidence, if you will, right? And that can depend on how strong an inference might be drawn from DNA, for instance, right? Or perhaps other factors that you would consider in weighing the evidence. But at the end of the day, evidence is evidence. Okay? So I would urge you not to get too caught up in the direct or circumstantial evidence analysis. Just look at the evidence and make your own assessment in terms of what the weight is to that evidence. All right. Now, a critical instruction is actually the instruction that lays out the definition of the burden of proof, in this case, on the state, our burden. And our burden is to prove the allegation and the charges that we brought beyond a reasonable doubt. We talked a little bit about this in jury selection, right? And now you have the instruction. Here's the issue, and this may be frustrating for some of you. There's really no good way to quantify reasonable doubt, right? The process of making an analysis as to whether something's been proven beyond a reasonable doubt is just, quite frankly, a human process. It's a human assessment of the weight and value of certain evidence, and whether you get to a certain point of being convinced, if you will. And there's no metric that we can put on that, right? So it's really impossible to express this definitionally in any way that gives you any kind of measure. That means that each of you have to think about this definition for yourself, and I would urge you to talk about it collectively as well as you're going through this evidence. And unfortunately, it also means that in the definition of beyond a reasonable doubt, we use the words reasonable and doubt to reference back, which is, I know, kind of violates, third grade English or whatever, where your teacher said never use the word you're defining in the definition of the word. But here we're really defining a concept, and that's a little bit different. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If after such consideration you have an abiding belief in the truth of the charge, an abiding belief in the truth of the charge, then you are satisfied beyond a reasonable doubt. And it's that line, the last line I kind of emphasized in italics because it is the one line that doesn't use the terms reasonable or doubt. Okay? It talks about this idea of abiding belief, meaning you've looked at after such consideration, you've looked at all of the evidence, right? Really evaluated the evidence, looked at it in its entirety. And from that evidence, you have a belief that the charge brought is true. And that belief is abiding, it is lasting, it is continuing, right? Then you are satisfied beyond a reasonable doubt. It is not beyond any doubt whatsoever. And remember, we talked about this in jury selection, right? Don't make the burden higher or don't make the burden impossible, please, right? Keep the burden at what it is legally, and that is beyond a reasonable doubt, an abiding belief in the truth of the charge. But there is another burden in this case, and another legal issue for you that you'll be considering as we go through this, as you go into deliberation, and that is what we've been referring to as not guilty by reason of insanity, or as you heard in the testimony, this idea of NGRI, okay, which is probably the phrase that I'll use in a closing argument just to make it a little bit more efficient to talk about that terminology, NGRI. This is a little bit different because while the state has the burden of proving the charges that we've brought, the allegations that we've brought beyond a reasonable doubt, insanity is a defense. Insanity is a defense. And therefore, the burden of proving a defense is on the defendant. And kind of when you think about it from a logical standpoint, that kind of makes sense, right? Their defense, they prove it. Now, the burden's a little different because they have to prove it by a preponderance of the evidence. More likely than not. More probably true than not true. So they've got to cross that probability line, okay, to make it more probable than not probable. And here's the definition of NGRI, right? I'm sure we'll spend a little time talking about this. I'm going to be focused more on my burden in this argument, okay? But I'm pretty sure defense is going to be talking quite a bit about this burden when they give their closing argument. So let's just look at the definition quickly. For a defendant to be found not guilty by reason of insanity, you must find that, 1, as a result of a mental disease or defect. So that the defendant was suffering from some sort of mental disease or defect at the time. The defendant's mind was affected to such an extent that the defendant was unable to perceive the nature and quality of the act. In other words, his mind was so affected that he didn't really understand what he was doing. He didn't really understand what his actions, the consequences of his actions would be, in the sense that he would be hurting somebody, taking a life, inflicting harm. All of those kinds of things. That's one. My kind of recollection of the testimony here, as you go through it, will be that wasn't really a disputed issue, even by the defense expert. Okay? I'm sure we'll talk more about that. The second thing is that, and this is an or, so it's not and, it's or. It's one or the other. Okay? Or that the defendant was unable to tell right from wrong with reference to the particular acts with which he is charged. The right from wrong. Tell right from wrong. Okay? Now, make sure you understand in the instruction, and look at this, that it doesn't necessarily mean that he has to know that what he is doing is wrong or right. That's not what the instruction says. The instruction says he has to understand the difference, to tell the difference between right and wrong. And that can be an important concept to think about as you're deliberating, I would submit to you. It kind of distinguishes this idea that, well, I'm sure we'll be talking about as we go through this, between somebody who believes they're justified and somebody who believes or isn't actually able to tell the difference. Okay? So you can kind of think about that as you continue thinking about this defense. Apologize, my PowerPoint has moved. That's what has just coming in there in the wrong place is the burden of proof, preponderance of the evidence, right? Preponderance of the evidence means that it's more probably true than not true. Okay? Above all, please don't forget about one of the most powerful tools in your toolbox, and that is your own common sense. It is, in my view, the very reason we have 12 of you, the very reason that we have a jury bring their collective experience, their collective understanding, their collective common sense to a table to talk about a case and make a decision, as opposed to having one person do it, right? Common sense is an incredibly important tool. And so I would ask you to always make sure you're checking in with yourself on that. Okay, so let's get into the charges here. And I'm going to spend a little bit of time with this because I'm sure as you were, as Judge Skinner was going through that final instruction, there was like, if you reach a verdict on this form, you use this form and this form and this form, and there's method to the madness, I assure you, right? And so I'm going to try to kind of take you through that in a logical way so that when you look at those forms, hopefully, if I've done my job, it'll make a little bit more sense as you go back and you start looking at that in the jury room. In this case, there's essentially two charges brought for each victim, for Davido and for Karen. And they are, while they look very much related, they are very much related. You have the duty, responsibility to look at both and to consider both, right? They are linked together in commonality of elements, right? But the jury instruction says you are to consider each charge separately. And so that's what you should do, is go through each charge individually and talk about whether that charge has been proven beyond a reasonable doubt. Okay? But the charges, again, are very similar based on two charges for Davido and two charges for Karen. Starting with Davido, count 1, murder in the first degree. Count 2, murder in the second degree. Okay? We're going to talk a little bit more about the elements of those and how what distinguishes those two crimes from each other. And again, you are to consider both, right? First count one, then count two. We have count three, count four. I guess realistically, the order that you consider it is up to you, right? But the idea is you consider all four of these charges. With Karen, you see it's the exact same charges, just relating to her, right? So count three is murder in the first degree with regard to Karen, and count four. There's another typo that I didn't catch as I was going through this. Count four. That's why this is not evidence, right? This is the tool, right? Count four. As it relates to Karen, okay? And I'm going to talk a little bit more about those. Okay. So with regard to counts 1 and 3, those are the first degree murder charges. One for Davido, one for Karen. Okay? The elements of that are 1, with premeditated intent, causes the death of another. Premeditated intent. And I want to spend a few minutes talking about this idea of premeditation, because premeditation, kind of in its common use form, may, to some people, make it sound like there needs to be a plan, like a thought out plan. But when you actually look at the definition of premeditation, the legal definition of premeditation in these instructions, you're not going to see the word plan anywhere in that definition. And here it is. Premeditated means thought over beforehand. Thought over beforehand. When a person, after any deliberation meaning kind of thought process, any thought process, if you will, any deliberation, forms an intent to take human life, the killing may follow immediately after the formation of the settled purpose, and it will still be premeditation. So the decision to kill can precede the execution of that decision, if you will, by only more than a moment in time, right? It takes more than a moment in time is the definition, right? And that's premeditation. So premeditation actually lays out, it's not about a plan, it's about thinking about it for however long, making a decision to do it, and then acting on it. And that can be however long or short is needed for those things to happen. Okay? Thinking about it, making a decision, and then acting on the decision. That's basically what this definition says. Premeditation must involve more than a moment in point of time. The law requires some time, however long or short, right, in which a design to kill is deliberately formed. The design to kill. So in other words, the intention to kill, the desire to kill, if you will, the decision to kill is made in a moment of time, more than a moment of time, prior to the act. It doesn't require a plan of how to get there. It doesn't require a plan of how to get away with it. It doesn't require any kind of a plan whatsoever. Okay? Premeditation is very simply that process of thinking about it, making a decision, and doing it. Okay? I want to be clear on that. For some reason, this computer has messed up my slides. Okay. There's an additional allegation in this one, and that is with both counts, and that is one, that the defendant was armed with a firearm. Okay? That additional allegation is something that is made as a legal accusation. Okay? In this case, I'm going to submit to you that it's relatively self-evident and probably undisputed that the defendant was armed with a firearm during the time of these acts, right? Nobody's really disputing that, I don't think. The cause of death was gunshot wounds. We've heard lots of evidence that would be consistent with that, right? There's really no evidence that they're of any kind of other situation, okay? The second one is there's an aggravating circumstance, and there was an instruction a little bit later in the packet talking about this idea of an aggravating circumstance. In this case, the state has alleged an aggravating circumstance, and that is that there was more than one murder that was committed, and that they were part of a common scheme or plan. There was more than one person murdered, and the murders were part of a common scheme or plan as the result of a single act of the defendant, right? Or the result of a single act. In this case, the state has alleged, and I would submit we have proven, that there was a common scheme or plan here, that Karen and Davido were killed together, and that was, in fact, a common scheme, that one was killed because the other was killed and vice versa. I'll talk more about that as we get more into the case, okay? And I want to be clear here that when you look at the instruction, make sure you understand that it doesn't say more than one premeditated murder. The instruction doesn't say that. The instruction says more than one murder, okay? So when you are deliberating on this, if you have got to the point where you're deliberating on this circumstance, okay, then the question before you is, was there more than one murder committed? Okay, not more than one premeditated murder. So I'm glad this one came through okay. It's frustrating when you change laptops and then all of a sudden things change. Okay, so here's kind of a decision tree. My best effort, if you will, to give you some kind of visual to think about in terms of your thought process on these particular counts. So counts 1 and 3, again, this is the murder in the first degree, Davido and Karen, okay? So in that decision, you've got essentially 3 choices, sort of, okay? One is guilty. The other would be guilty, not guilty by reason of insanity. Now the reason I say it's sort of 3 choices is you actually only look at not guilty by reason of insanity if you have first decided the defendant committed the acts and was guilty of the crime, if you will, because it's a defense to the crime, right? Okay? And then, of course, that third choice is not guilty, meaning that after your deliberation, you have come to the conclusion that the state has not proven the allegation beyond a reasonable doubt. Okay? Not guilty. If you find the defendant guilty of murder in the first degree, then we've got these other 2 questions for you to answer. And what you'll see is, in the verdict forms, you'll see verdict form 1, count 1. Okay? So every time there's a number on the verdict form, you can think that's to what count it is. Okay? That's how it's organized. And then each of the other, the questions that you're going to be asked about that count are contained on verdict forms, special verdict forms A, B, C, and D. Okay? So when the number refers to the count, and then the letter tells you which question is being asked. Okay? So if you find the defendant guilty of counts 1 and or 3, okay, then the first question that you're going to be asked is, was the defendant armed with a firearm? And there'll be a special verdict form that'll ask you that question. Was the defendant armed with a firearm? And then there'll be a second question. Was this part of a common scheme or plan, right? Were 2 people murdered and the murders were part of a common scheme or plan, okay? So you'll have those 2 extra questions to answer. If you go through the process and actually find Mr. Burke was not guilty by reason of insanity, then the other don't worry about those prior verdict forms, right? Now the special verdict form you're going to answer is a series of questions. And without putting all those questions up on the screen, I'm just calling them the NGRI questions. There's 5 questions that you'll go through that you'll answer, okay, if you get to that point. But the point of my diagramming it out here is so that you understand that, there's 2 verdict forms that go with guilty. There's a separate one that goes with NGRI. And if it's not guilty, don't worry about anything else because you are essentially done at that point with that charge. Okay? All right. Now let's go to second degree murder, which is counts 2 and 4. Davido and Karen. Okay? I'm anticipating, because I used the slide form here that it might have messed this one up too. We'll do the best we can. A second degree murder now drops the premeditation, and it's basically the intentional killing of another person, intentionally causing the death of another person. And intent simply means, you know, that that's the objective, that's the purpose of the person. And when they do the act, in their mind, their end objective, their purpose is to cause death, okay? There's no thinking over beforehand that's required about that. The intent could be formed contemporaneous with the act itself. It's just that you have to find that the objective was there, that was the person's goal, if you will, was to inflict death, to cause death, okay? That's one way of doing it. There's a second way of committing murder in the second degree, which is one of the reasons that you have this charge as a separate consideration as well. And it's what we commonly refer to as felony murder. That's not in the instructions anywhere. It's just the common describer, if you will, of this way of committing murder in the second degree. Felony murder. What that means is that the person is attempting to commit another felony. In this case, our allegation is that he was committing or attempting to commit either an assault in the first or second degree, okay, by shooting at or shooting Davido and then shooting Karen. There's an assault that's happening there. And if a person, if during the course of that assault, he causes the death of another person, not a participant. In this case, obviously, it's Davido, Karen, okay? And that is also a second degree murder, even though there may not have been the formed intent to kill. If there's the formed intent to assault, and the assault led to a death, then it's a felony murder, okay? And you actually will be answering questions on both of those things, right, as you go through your verdicts, as you consider your verdict for assault, for second degree murder. First degree assault means with intent to inflict great bodily harm, assault with a firearm. Okay, that's a first degree assault. A second degree assault is assaults another with a deadly weapon, and there's an instruction that says a firearm is a deadly weapon. Okay, so that's why it's either assault in the first or second degree. I'm not sure at the end of the day as you're going through this it's going to matter much to you. Maybe it will, because the evidence here supports the existence of a firearm, as I indicated. Again, on this one, there is that additional allegation that the defendant was armed with a firearm, which kind of, again, goes along with the nature of the case. So there will be a questionnaire as to that. So if we do the same thing here, and we look at kind of the same decision tree type model, it looks kind of like this. We now have counts 2 and 4 relating to Davido and Karen, okay? The same 3 choices: guilty, not guilty by reason of insanity, or not guilty. Same thing again, you get to NGRI only if you've found the defendant guilty in terms of having committed the acts, and then you consider the defense. If you find the defendant guilty and have decided that NGRI doesn't apply, okay, then there's 2 more questions. 1, armed with a firearm, and 2, intentional murder, felony murder. And you'll actually have on that verdict form both questions, right? Was it an intentional murder or was it a felony murder? Okay, it won't say felony murder, but that's the language that'll be described, that it happened, that during the course of assault 1 or assault 2 caused the death of another. Okay, so those will apply on that with a guilty finding. If in fact you do consider and find the defendant not guilty by reason of insanity, then you don't need to do those first 2, right? You just focus again on what I call the NGRI questions, those 5 questions that were laid out in the jury instructions. And then of course, again, if you were to find the defendant not guilty, done. At that point, no further questions need to be answered. Okay, so that's kind of the process. I hope that's helpful in terms of how this is laid out. So just keep in mind that in the verdict forms, the number is always going to refer to what count that verdict form is referring to, and then the letter is going to connotate which question that you are being asked. Okay, so let's dive into the evidence in this case. We've got kind of the law of the case out. We've got what you do, what you don't do, your role, if you will, the charges, what needs to be proven for the charges. So let's actually dig into the case. As her usual practice is going into the office very early in the morning. So she leaves her house at about 5 o'clock in the morning. In this screen, the points aren't very largely marked, but essentially we've got 2 points. One towards the lower right portion of this, one towards the upper left. And what this is, and you'll recall this from Mr. Salmon's testimony, is it's tracking the cell phone towers that Karen's cell phone is hitting as she goes from home to work. And it's useful for a couple things. One is it helps us with the timeline, right? Because we know exactly the time it occurred. And a little bit about path, although her path to the office isn't terribly relevant or important in this case. But it does tell us that she goes straight there, which is her usual practice. So it's kind of a typical Friday, if you will, from all appearances. So as we watch this video, you'll see that this is the tower that basically is being used by her phone when she's at home. And as her phone moves, according to the route, she ends up then at her office. You recall that the way this works is that we have these, as Mr. Salmon called them, these fans, right? So it tells you the direction that the phone was in from the tower, right? And so there's about a 120-degree angle, it's somewhere in that. And then the arc tells you how far away. So by drawing that arc through, you get a sense of the approximate location of the phone. Admittedly, not the exact location. And so we see the phone travel from Karen's home to Karen's practice at 5 o'clock in the morning. At about 2:30 in the afternoon, 2:35 in the afternoon, we see the same thing. Davido leaves his house and goes to the Stedman property. Now this one has a little bit of a route to it when you watch this. And if you look and you're kind of familiar with the map in the area, it looks like he travels over to Tumwater first and perhaps retrieving something that he needs. We don't really know, it's not in evidence, but it goes into kind of that area of Tumwater where Home Depot's there, Costco's there, or whatever. There's lots of businesses right there. But it goes there and then maneuvers back over to Stedman Road. So it's not necessarily a direct path. Let's take a look at this. All right, and so he arrives there at about 3:22 in the afternoon. That explains also why it takes longer for him to get there from home, because home directly to Stedman is certainly wouldn't take that long. Okay, again, it seems like things are pretty typical that day. Now let's look at the data from Mr. Burke's phone. This is at 3:59 in the afternoon, and this is basically the kind of corroborating that the phone, if you will, is with him and goes with him to the Stedman property. Okay, so where this starts, we're not really able to determine exactly where he is when the track starts, other than he's somewhere north of the Stedman Road property and travels down to a place consistent with Stedman Road. Okay, so he arrives there about 3:59 p.m., so just almost 4 o'clock in the afternoon. Davido purportedly has been at the property now for a while, an hour and a half or thereabouts, working. And when he arrives, they have a conversation, right? And we have the video of that conversation because Mr. Burke records it on his phone. And what I want you to do is now, we'll watch this conversation again, and kind of having the totality of the evidence in your mind, be thinking about this conversation. Because while it starts with, kind of a confrontation of words, not physical, but, hey, you took Marshall's side, Mr. Burke, accuses him of taking the side of another tenant. Davido's kind of pushing back on that, saying, well, this is what I'm dealing with, and talk about that. And so they kind of work through that, and then at some point they've reached the end of that confrontation or discussion, and they transition, and they have another conversation about what apparently is some kind of a construction project they're working on together. They're working on some kind of a building plan or something, because the defendant says something about we should do some drawings at one point in time. But again, watch the interaction here, because what you'll see is what I would submit to you is a fairly kind of typical interaction that might occur between a couple of people in this type of situation. By the way, this has been intentionally left on its side a little bit because the phone kind of rotates as we go through, but it was the easiest way to be able to see it on the full screen.
So I'm recording. I'm just going to re-record all the time because people seem to be saying things. Look, you said that I started the incident with Marshall.
Yes.
But you weren't there. You didn't see what happened. You didn't look at the video.
You didn't send that video, did you?
I offered to show it to you, but I can't really just send it to you very easily. You didn't say you wanted to send it.
I'm happy with it.
Okay. Well, I did tell you what happened. He came and blasted his lights at me.
He had his lights on, yes. He's entitled to do that. I don't see how that is a problem.
Well, when you drive up like right next to somebody and you blast your high beams when they're trying to work in your area, that blinds them.
So then you just say, would you turn on your lights, please? They're trying to work it.
Well, that's basically what I said.
It might have been basically what you meant, but it's not the way you said it. And there were people here that heard it. So. It's not just Marshall telling the tale.
He was doing that to bother me and harass me.
That is
My response was a reaction to that.
Yes, I understand. So you are entitled to interpret it the way you want, but that's not relevant.
I heard some bad stuff's going on with Julie.
In what way?
I know she just said she's having a hard time.
Well, see, her car is not she didn't have a problem. Her car was overheating. She thought it was a head gasket. She left the park. They towed it. So one problem after another.
Is her dog doing that? Is she here?
Well, that's right. She is not. Oh, she is not one to talk to this.
Driveway, huh?
Yeah, she's worried that she's gonna slip on the mud in her gravel path. I'm just gonna pull part of it. The layout I picture for the water line, drain line, power line.
Okay. Yeah, I think that'll help because right now it just kind of looks like a spaghetti mess. So, if I have an understanding, I do have the layout of the appliances and fixtures, but
So when you build the walls, it's going to be important that you pay attention that the walls do not. Pay attention to where the drain ports are because you have to have access to them. When the tub gets there in, I'll send you a distance on the tub drains so you understand it. The wall can only come so far.
right, I know, yeah. Otherwise, you can't get the toilet in. Okay. Well, and then it's going to be a little smaller because of the block walls underneath the edge. Well, the block wall is 8 inches, and then so it's minus 8 inches on each end. The block wall. And the carport. Yeah.
Probably that will be on the outside of the, well, I don't know where the block walls were.
Well, it's got to go under the roof. So
There's already a wood foundation beam. And on top of that is the metal stud, foundation stud with the whole time. And so the question becomes, is the block wall going to be over the center of that stud? Is it going to be on the outside of it? Or the middle stud? Or is it going to be on the inside?
Okay.
So if you put the blocks on the inside of that metal stud, then there's going to be a problem. You have to, well, not a big problem, you just have to redo a point. If you put the blocks on the outside of that stud, or you go to the center, then you should do it.
Why would you have to redo the plumbing?
Because I measured from the outside of the stud, the outside of the metal stud, here's a metal tube running along the top of the foundation.
Well, I think we're going to have to do drawings sometime.
So I measured from the outside of that tube, here one is in. And then here will go.
So he leaves the property about 4:06. There's a little bit of time here of just him recording himself driving. But one thing to take note of in that interaction is that there's this kind of conversation about how to do this and how to do that. And I want you to think about Mr. Burke's, how he's thinking, how he's engaging, right? Well, how does this, he's asking questions. What does this mean? Why would that change the plumbing? And Davido's explaining it, right? Fairly normal interaction. At one point, Davido gets in the truck to pull ahead. Mr. Burke is, if you look at the phone, pretty much standing right there by the truck, watching him pull ahead. And then, they finish this conversation and Mr. Burke leaves. So when he leaves, where does he go? Here's now from 4:06 when he leaves the property. We look at the phone data, and it tracks him on a path. And what you'll notice is the 3 points of interest that have been marked in these maps, as usual, is the Stedman Road and the house address, Davido and Karen's house, and Karen's place of business up towards the top. And the phone settles there. So where was he? What was he doing there? It's not very conclusive based on the evidence, other than we know that the cell tower that his phone was hitting, and the fan that's created with directionality and the arc is very close to Karen's business. It's an observation. It's something to think about and consider as you're looking at his movements. Okay. All right. So meanwhile, at 4 o'clock, Karen has actually left her place of business. Okay. Again, this is kind of her routine. She's been there since 5 o'clock in the morning, or shortly after, as we saw. 4 o'clock rolls around. She heads back to her house. Takes her about 17 minutes to do that. Nothing, again, apparently unusual about that, other than we simply followed her phone back along what essentially appears to be the same route back home. All right, and there she ends up at home for her Friday night. So this is the defendant's phone path now for the next several minutes, and it's kind of sped up. I think Mr. Salmon kind of sped it up into a time lapse. But let's just watch and see what his movements look like at this point. Okay, so he's moved away from the spot up north, moved to the south. Again, we don't really know where he is or what his location is, other than it's somewhere in that area. But at 5:27 then, what we know is that his phone connects to the cameras at the Stedman Road, the cameras that he has access to on his phone. And one of the videos that's captured on his phone is a video of Davido leaving the property. Okay? So watching Davido leave the property. This is at about 5:27 p.m. The video starts a minute beforehand.
But you'll see essentially Davido get in the truck and pull out and drive away from the property. That video is interesting for a couple of reasons. One is it helps our timeline. So we know that Davido left the property just short of 5:30. But the other thing is we know that Mr. Burke at least had a way of knowing that Davido had left the property at a little bit before 5:30 and presumably gone home. So if he's thinking in his mind about a need perhaps to re-engage or confront Davido on something, he now knows that Davido's not at the property anymore, or at least has a way of knowing that through this phone video in order to be able to know where Davido's located. Davido's phone path then shows us basically him taking a route home. It only takes him several minutes to get there. This is the direct path, presumably, to his house. So Karen and Davido now are both home, about a little after 5:30 in the evening. Now at 5:36, just about the same time that Davido is arriving home, Mr. Burke turns his phone off, powers down his phone. Now remember the questions that he had been asking, and we'll see some of those questions as we go a little bit further, but in his mind was that question, can a phone be tracked? Can a phone be tracked? And he powers the phone down. This is presumably before the murders, before the shooting, right? 5:30, Davido has basically just arrived home, and the defendant now is powering his phone down. And I think something for you to consider is he powering down in order to not be tracked? But then at 5:55, it powers on for a brief time. And guess where it is when it powers on? In the exact fan and distance area of Karen and Davido's home. Now this, again, is at 5:55. So what we know from other testimony, and we'll talk about it, is that the shooting likely occurred later than that. You recall one of the things that Mr. Burke talked about in one of the interviews that was done was that he went to the house originally to watch Davido, or to try to, see if Davido was home, to look for this body bag, as he put it, right? And that he actually sat there for a while, and was contemplating what to do next. So that would be consistent, right, with this timeline, that he's at 5:55 there. He turns the phone on for a brief minute, and then a few minutes later, he does this search, right? The search is, do Android phones store a record of where you were? Okay? And the answer to that, the AI answer that came back to that is, yes, Android phones can store a record of your location history if you've enabled location services and Google location history, and then it goes on from there. Okay, so now he's actually asking that question, can my phone be tracked? And getting an answer. So what happens next? The phone gets turned off. Okay, the phone powers down. And this is at 6:01 p.m. So it's only on for about 5 or 6 minutes, and then it powers back down again. And I want you to think about, again, is this a thoughtful process? Is this somebody who is actually in a thoughtful process? Right? Thinking about what's going to happen. Thinking about what to do. Okay, that kind of thing. Now it comes on again at 6:24. So this is about 20 minutes later, thereabouts. And at 6:27, there's a call made to Nina Christina Collins, which we know is, I believe, a roommate. I think Jocelyn said that was a roommate or a friend or something, but somebody that the defendant would reach out to from time to time to check on Jocelyn's well-being or whatever. So that call is made. And look at the location here. This is not a video. This is just a location marker when that phone powered on. And here we are now, same place, okay, within that, or near the vicinity of Karen and Davido's home. Then, a few minutes later, following that call, the phone is turned off a third time. So now it's clear that the phone is coming on for kind of a specific task, and then it's going off again. Okay? Again, kind of think about what does that mean? Is this somebody who's being thoughtful and contemplative in what they're doing, right? And thinking about what's happening and what's coming, what they are doing or planning to do. Then we know that basically sometime between 6 and 8 p.m., Angkor Yoon returns home. Now, she comes home from work about 6. She says she's there for a while watching TV and believes that she went to bed about 8. And sometime before going to bed, she hears these things that, in hindsight, she looks back and it's like, oh, those were gunshots. At the time, I think she was kind of like in this little state of denial, right? I mean, that's really up to you to consider, but she's kind of described this thing like, I was hoping it wasn't what I thought it was, right? But now in hindsight, she realizes, yep, it was exactly what I thought it was. But the interesting thing about this that I want you to know is that she described very clearly the pattern, right? She said 3 or 4 shots in kind of succession, boom, 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 right? And then a pause, and then a final shot, okay? So if you go with 4 as her estimate, 4 in a succession, and then a final shot, 5. Without any knowledge about the scene or anything else, she describes 5 shots. And guess how many shots we know from the scene were taken, or what the evidence tends to show? 5 shots. So that really corroborates what she heard and when she heard it. And it was sometime before her going to bed, around 8 o'clock in the evening. Okay, I would submit to you, when you start to look at this evidence in its totality, along with this specific piece where a neighbor hears what she now realizes was gunshots, in that pattern, Karen and Davido have just been murdered in that period of time. They have lost their lives in that period of time. All right, we go to the next day, November 11th, because Mr. Burke's phone doesn't come on again. Okay, so basically things go dark now. The next day at 3:28 p.m., there's an email that comes from Mr. Burke's Google account. So that could be, there's no phone records active here, so that could be computer, right? Anything to access Google. And look at the interesting context of that email. I have been leaving you alone, but I might just be doing that for a very long time. I want to say I've always loved you with all my heart. This is from Mr. Burke to his daughter Jocelyn. Okay? But I've failed you due to being angry at you. I should have gotten a private attorney, but I was upset about you not cooperating with bringing the family back together. I hope you are still alive, and I'm sorry for how I've handled many things. I hope you can be wiser than me, make better choices, be more thoughtful about the intricacies of dealing with people who are potentially dangerous. Okay? And think about the context of that email. So in this scenario, if in fact he has now murdered Karen and Davido, this is the email that essentially alludes to that, to his daughter Jocelyn. Essentially a kind of an apology. Then a laptop search. Do Android phone track GPS when off? So a similar question and a similar answer. Generally, an Android phone cannot be tracked via GPS when it is completely turned off. The prior question was, can they track it when it's on? Now he's asking, can they track it when it's off? Okay? And it says, generally not if the power's off. Some modern phones may still be locatable for a short time because of power tracking capability. Okay? So that's a clue again into his thinking. Why is the phone going on and off? What's going on there, right? Why is it powering up and powering down? Now, on November 12th at 3:32 in the morning, Mr. Burke is in the laundry room at the Stedman Road property washing or doing his laundry, presumably, washing. He's active there. And we have this video confrontation that occurs between presumably who's the kind of on-site person that lives in this residence, who's not happy that he's in there doing laundry at 3:30 in the morning, essentially woke her up from her sleep. But again, watch Mr. Burke and how he interacts, okay? Because essentially now we're just about, well, not even 48 hours after the murders.
The laundry is off limits 10 p.m. to 8 a.m. It is closed.
Seems really angry.
Yes, I am.
That's not the way it is in my lease.
Well, you know what?
I'll try to
I don't
already
care.
said that.
I don't care what your lease says. You just woke me up. And I get up at 4 o'clock in the morning every goddamn day to go to work.
Okay. I already said I'd be quieter. Did you not hear me?
Quiet is nothing. Get out of my house.
This is not part of your house.
Oh, yes, it is part of my house, and it's closed 10 to 8.
Are you fucking threatening me or something?
No, I'm not threatening you, and don't swear at me. Don't swear at me.
I'm recording.
Go ahead, record whatever you want to record.
Don't bother me when I'm in the laundry room again.
Do not come into the laundry room at 3:30 in the morning.
Or what?
Or what? You're going to get a notice. Thank you very much. Goodbye.
I'm not disobeying my lease. I already said.
Goodbye. Goodbye. You're disturbing me.
Fucking entitled.
You know what? It has nothing to do with entitlement. This has to do with communal living, and you do not do things at 3:30 in the morning when somebody else is trying to sleep.
Now,
You
what
don't
are
do
the
it.
things that you do to people?
And really?
You don't think I know?
You know what? It doesn't matter what you think you know. You don't know.
Yeah, you don't think I know.
And you have absolutely no common sense.
So what part of I'll be quieter do you not understand?
You know what?
I already said I'd be quieter.
And there's that thing in my face. You and your lights.
My light's fucking over here, you retard.
Oh, calling
It's
me.
not in your face at all.
Really? Calling me.
Which part of I will be quieter do you not understand?
Not do anything.
You just want to fight. You just want to fight. I already said I'd be quieter.
Conversation. No.
You just want to fight on and on and on because you enjoy conflict. You enjoy conflict. There's no point in talking to you.
Well, again, this is a confrontation. He's dealing with somebody who is very obviously angry, right? A person who is confronting him, woken her up. And yet we see his response to that to be, again, he's pushing back. He's engaging, right? He's thinking about the arguments. Well, that's not in my lease, and I told you I'll be quieter. I'll do this. He's trying to, seek a resolution, if you will, but nothing that would indicate that he has lost his ability to engage and communicate and to think through what he's doing, all of those kinds of things. And now we have, later in the day, that same day, this is now the evening, because again, there's kind of like nothing data-wise that appears during that day of evidentiary value, but we have now him appearing at the ATM where he uses Davido's debit card, to withdraw money from the account. There's no sound with this, but again, I ask you, just watch his demeanor. Watch how he interacts with things. We've got goal-driven behavior there. He's looking to get some money. He can navigate through the process. The first card he puts in appears that he doesn't get what he wants. There's a little kind of almost like a flash of frustration that goes across his face, goes in second card, is able to get money, and leaves. So, again, clearly he is able to navigate these circumstances to get to where he needs to go, okay? All right, so then we come to November 13th. This is the Monday, 8 o'clock in the morning. Kathy Pratt is at work. She's getting very worried about Karen because Karen has not shown up, and that is very unusual. Bert, her husband, you'll remember, agrees to go over to the house. When he gets over to the house, he finds it locked up, windows, shades all drawn. He can't see inside. He doesn't know what's going on. So they call law enforcement to come out initially to do what is commonly referred to as a welfare check. Okay, see what's going on, check on their welfare. The sheriff's deputies come out. They're able to get the access code for the garage from a family member. They go in and discover the scene that we saw in the photographs. Here's the inside of the house. This is the 3D image and the floor plan. What we know is that law enforcement came in through the garage, proceeded in that hallway that's kind of being called the south hallway, if you will. Was able to observe that fairly substantial pool of blood right near the front door of the residence. They also then observed a blood stain. You can see it particularly in the 3D image, in the middle of the living room floor in front of the sofa. Proceed into the back bedrooms. They see the damage to the wall and so forth, and immediately then know that something is not right. Obviously, something has happened at this scene, and they back out, and now that has become essentially a crime scene. Here's essentially some of the key observations that they made. Going into the garage, you remember the things that Karen would normally have in the trunk of her car have been taken out. We learn later that there's various blood patterns in the garage, consistent with the bodies having been carried out of the house. Mr. Nodell talked a little bit about that. We see the fairly substantial blood saturation in the living room in front of the sofa, the blood pool in the south hallway, the 2 bullet defects, which are important in this case, in the wall above the chair, and then of course the area in the hallway where it looks as if somebody has torn out the wall board there to try to retrieve something, presumably a bullet in there. And what's discovered later, when the crime scene team is actually in there, they discover this kind of bullet laying over on the right side of that hallway, near the right wall, that center photo. Around 9 p.m. that night, they find Karen's car. So there's lots of work going on, right? They're going through the scene, collecting evidence, examining the scene. They attempt to locate out on Karen's car, and sure enough, it shows up at around 9 o'clock in the evening, parked backed into a stall near the Chehalis Western Trail. Okay. In there, they find what turns out to be some key important pieces of evidence. One is the glasses case that has a fire bullet and 5 casings in it. In addition, they find another bullet just kind of lying in the back seat area of the vehicle, just kind of lying there loose. There's blood stains that are noted, and then particularly they take swabs from the steering wheel, just to, because if you're going to try to determine who might have been driving a car, an obvious place is to take some DNA swabs to see if there's any touch DNA there. And we now know that they find out later that Mr. Burke's DNA is on the steering wheel of the car. Okay? And then we move to December 2nd, where Karen and Davido's bodies are finally located by Alan Cook and his son, who are simply out looking for trails, dirt bike trails or whatever, and happen to just spot these bodies in an area which is very thickly wooded. If you were going to hide a body, this is precisely the place to do it. Very thickly wooded, very rural area, away from Stedman Road, but not far from the property. If you recall, the paved portion just at the very bottom of this photograph here, this is Stedman Road. You go down Stedman Road a little ways and you end up at 10135 Stedman Road, which we refer to as the Stedman Road property. These are photographs that I've included just again to remind you how densely wooded this area, how thick this was. This wasn't just, it took some work to get Karen and Davido's bodies into this area, right? It took some work and some intentionality to do this. All right, so now we've moved to the area where we've got the DNA evidence, and I'm just going to highlight that really quickly, okay? We know that it was Karen's blood in the south hallway. I've couched the slide in the terms that our scientists use, but when she uses the word very strong support, she's talking about those numbers that nobody else understands, right? 10 to the 30th, 10 to the 32nd power, whatever it is, right? Very strong support. So we know that's Karen's blood and that she ended up in the south hallway. We also know that the living room carpet, that's where Davido was shot and killed. And that's his blood on the carpet. We also know that there was strong support. There's a mixed DNA sample from the Sienna, that's the defendant's vehicle, from the passenger door that included, it was very strong support for Davido, okay, moderate support for the defendant. So Davido's profile was the dominant profile, obviously, and probably a blood transfer or something of that nature. Very strong support that the DNA from the bullet in the Yaris, that's in the rear passenger, was from Davido. That had Davido's DNA on that bullet. Remember, one explanation for that, how that bullet got there, might be that the bullet was caught in Davido's clothing as it passed through him. And so as the body's being manipulated and moved around, the bullet falls out of the clothing and ends up in the car. Something that perhaps somebody who's doing the manipulating doesn't realize, right? Doesn't detect or realize that this bullet now has been deposited there. And then very strong support that the blood found on the rear cargo floor mat of the Yaris was from Davido, suggesting Davido's body was in the back of the vehicle. And we have, there's a mixed profile from so a piece of upholstery from the Yaris, some support for Davido, but very strong support for Karen, suggesting that Karen was either in the back seat or somehow in, across the back to the back seat or something of that nature. Very strong support that the DNA located on the steering wheel and the gear shift of the Yaris was from the defendant. So at some point he had touched the steering wheel and the gear shift of the Yaris. Strong support that the DNA located on the glasses case was also from him, which would indicate that he touched or handled that glasses case that contained those shell casings and that bullet. Strong support that DNA located on the gloves by Karen's body. So you remember there was a bag found by Karen's body that contained a bunch of stuff, and in that was some blue acrylic or whatever that material is, gloves. And on one of those gloves they found the defendant's DNA there. So we've got now 5 shell casings and we've got 4 bullets. You remember, one bullet comes from under the floor in the house, one bullet found in the hallway of the house, one bullet in the back seat of the Yaris, and one bullet in the glasses case. And then all 5 shell casings are in that glasses case. Those are all analyzed, and they're compared to the FN 45 auto caliber handgun that was taken from the defendant when he was contacted on the 13th, and sure enough, they all match. They all match the gun, right? And Ms. Walsh, the scientist, was, I would suggest to you, pretty confident that there was enough evidence there that she could say it was a match, right? So with that, we can infer that the gun found on Mr. Burke was the gun that fired these bullets, fired these shell casings, and particularly for the bullet in the Yaris that had Davido's DNA on it, he fired a bullet in such a way that Davido's DNA ended up on that bullet. Okay? The evidence is stacking up. So then we start to talk about, well, what happens when we put this together from a reconstruction standpoint? This was Mr. Nodell's task. And what he notes is this spatter pattern, right, which suggests that there was at least one round that had enough force and was close enough that it would cause this high velocity spatter to go out and to touch these other things, the sofa, the television, and the blinds. Okay. We also know there was the hole in the floor and the bullet underneath. And from that he could infer that at least one shot was mostly downward, went through Davido, through the floor, and into the crawl space where it came to rest there. Now when we talk about care, and by the way, I put the Davido's the gunshot wound. So this is as described by the coroner, right? Gunshot to the left side of the head, through the head, okay? A gunshot to the upper back, exiting the chest, and then a gunshot to the upper abdomen, left, right upper abdomen, exiting left torso, okay? Lateral torso. So one here, one in the back, and then one here. Think about those trajectories, okay? Because what Mr. Nodell told us, that what he could infer from that is either that Davido was moving, or the gun was moving, or both at the time that the shots were fired, okay? But it's likely that the gun was not firing at Davido while he was stationary from the same place, because those trajectories don't line up that way. With Karen, it's a different story, because if you actually turn her head a little bit, the trajectories line up. And what it demonstrates, because we've got those two bullet holes in the wall, that's why these are so important, it tells us Mr. Nodell can actually do that trajectory analysis, and he can determine that the gun didn't move much, right? Because the trajectories are very similar through that wall, and the pattern is very close together, the pattern of the two bullet holes. Yet, the injuries to Karen are a ways apart. She has a gunshot wound to the left side of her head, they say exiting out the other side, okay? And then a gunshot wound to her right chest, exiting out her back. They don't line up unless her head is like this, right? If her head's like this, then they line up. But the issue is the vertical movement. So there's some vertical movement. That would suggest that Karen was either sitting up and was shot twice as she was getting up, or she was shot and started to go down and shot again, because her body's either moving up or down during the course of those shots. And then Mr. Nodell was able to say, based on his professional experience, that she fell to the right because we had that blood trail, right? That kind of meandered over, and then the blood pool. So what that tells us is, I would submit that, and there's directionality here from essentially where those shots were fired. That those shots were fired relatively close in time, while Karen was either sitting in the chair and getting up, or she was standing in front of the chair and went down as she was shot the second time, one or the other. And then finally we end with the interview from the psychologist. And I'm just going to hit a couple of highlights because I'm sure that I'll be talking more about this in my next argument after defense has had their chance to talk more about this. But here's some key pieces of evidence as it relates to our burden of proof, okay? Remember, our burden of proof is to prove the charges beyond a reasonable doubt, okay? The defendant actually admitted to the defense psychologist that he went into Davido's home because he wanted to investigate what he believed to be a body bag, determine if it was JB, his daughter, and call police or kill him. Now, if that's the case, then what we have there is contemplation. There's contemplation going on. I'm going to do something about this, right? I'm going to find that bag if that's really what his subjective belief is. I'm going to do this, and I'm going to do something about it. So there's contemplation going on. And isn't it interesting that one of the choices of that contemplation was to kill him, right? A person that he had already previously labeled a narcissist. God told him not to bring the gun, but he did it anyway, demonstrating his ability to choose, to exercise choice, right? To keep agency, his sense of agency. Davido tries to punch him, and defendant falls on top of him. There's some kind of skirmish where then he knocks out Davido. A point which I would submit to you should be questioned based on those trajectories I talked about with Davido. Okay? He told the defense psychologist that he actually shot at Karen first, but didn't hit her, is the way that he described it. Or at least he didn't describe hitting her because he said she continued to move towards the garage. Meanwhile, he shoots Davido, presumably while he's down on the floor. Then goes back and shoots Karen as she's standing by the garage. And he said to the defense psychologist that he did it because he was afraid of her calling the police. Common scheme or plan, right? If he committed a murder of Davido and then realizes that he's got to now stop Karen from calling police and being a witness, and he kills her, common scheme or plan. Common scheme or plan. There's the nexus. Let's look at what he said to the state psychologist. There's similarities, but there's some differences. He thought he saw Davido with the body bag, but left instead of actually doing that investigation. So that's when he goes to the house the first time, he contemplates what he's going to do, he leaves. He returns, but when he returns, he parks on the main road, and he walks into the house. He walks up to the house. Now think about the significance of that. Again, if you're thinking about somebody who's contemplating, who's thinking about what they're going to do, and they don't necessarily want anybody to know that they're coming up to the house or that they're there, wouldn't it make sense for them to not drive the car up there, but to simply walk when it's dark to the front of the house to get entry? He bursts into the house. Davido tries to punch him. Davido tried to fall down on purpose, he said. Of course, now he's saying that Davido's trying to play the victim, which I would submit to you makes no sense given the circumstances of what's going on, and particularly since Karen's there. That just, you decide for yourself whether you think that makes sense or not. He falls on top of Davido, punches him in the face, and again says he knocked him out. Okay, so presumably that means Davido, again, unconscious, helpless. He gets up, he sees Karen with her phone, and he shoots her. Okay? When asked why he shot her, he said, again, I thought she was going to call the police. I thought she was calling the police. There's that nexus. There's that common scheme or plan. He then shoots Davido while he's down on the floor. Again, presumably unconscious or not moving. He goes into the garage, looks for the body bag, doesn't find it. He drives around, then he decides to go back and clean up the evidence, right? He realizes he had a problem, but he didn't want to be in trouble. So he brings the bleach, he cleans up the shell casing, he disposes of the bodies with the intent to go back and later bury them. But he chooses not to do that because he's afraid that he's going to get caught. Okay? What we have here, when you start to look at this evidence in a totality, is a clear story, ladies and gentlemen, of the first-degree murders of Davido and Karen. He went to that house. I don't know if he, and I don't know that the evidence tells us whether he had a plan to kill Davido, but he was certainly thinking about it. He was contemplating it, right? He goes into the house. He maybe there's this altercation, maybe not. The only version of that we have comes from him. But at some point, Davido goes down on the floor, and he shoots Karen, and he shoots Davido, and kills them both. He's essentially admitted that, right? But think about what it takes to do that, right? We've got a shot with Karen, a shot to the chest, and a shot to the head. Had he really not thought about that beforehand and made the decision he was going to kill Karen? When you point a gun at somebody and you shoot them in the side of the head, isn't that a decision to kill them? Right? And he only need make that decision more than a moment in time before actually executing on that. And the moment he said, I thought she was calling the police, he made a decision. And he executed on it. And then with Davido, Karen is now down, presumably. He turns his attention to Davido. He fires 3 rounds into him. Again, another one through the head. That's a decision. That's a choice. Right? That is a choice to kill. A decision to kill. But I want to come back and remind you of what the neighbor said. 4 rounds, pause, and then a final round. Davido has 2 rounds to his torso, non-lethal rounds. Okay. Karen has 2 wounds, and then Davido has a final headshot. And we also know that at least one of the rounds that hit Davido was virtually straight down through the floor. So let me suggest this. He didn't knock Davido out, he shot him twice. And Davido went down. He turns his attention to Karen because Karen has her phone and she's about to call the police. And he fires 2 rounds at her. One in the chest as she's standing there. She starts to go down, and the next one to the side of the head. Pause. He then walks over to Davido, who's presumably on the ground now, and fires one through his head, the coup de grace, the bullet of which ends up in the crawl space. That matches the physical evidence, ladies and gentlemen. And it's a scenario that actually more aligns with the evidence than his version. Now, it doesn't have to be that scenario. There are other scenarios, and I'm sure you'll talk about them. But I'm confident that when you do talk about this, and you actually think about what was going on in that house, and the decisions that Mr. Burke made as a result of what he was in there to do, he made a decision to kill Davido. He made a decision to kill Karen. And he did it with premeditation. The state has proven, beyond a reasonable doubt, the first-degree murders of Karen and Davido. Thank you.